Sergeant Lowe.
Sergeant Away. Is that it?
Yep.
And that's and then you said Miss Wicks is here for Mr. Nichols.
Yep.
Sergeant Away. So we're on the record in docket 22-00822. That is People of the State of Michigan versus Sergeant Away. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Taylor Wicks, Assistant Public Defender, filling in for Scott Nickel on behalf of Mr. Huawei.
All right. And sir, you are Sergeant Away?
Yes, sir.
Okay. Mr. Wisty, this is the time set for a preliminary examination. How are we proceeding today?
Your Honor, it's my understanding the defendant will be waiving up. This is part of a larger plea agreement in another encompassing a case in another court. At the circuit court level, this case, the agreement would be this would be dismissed in exchange for a plea to carrying a concealed weapon with a HIDA recommendation once it reaches circuit court. Today.
All right, and all that will take place in circuit court?
Correct, Your Honor.
All right, so let me make sure I have that just for the offer for the file. This is a waiver today. And D will be pleading in a global resolution to
Carrying a concealed weapon, Your Honor.
Ms. Wicks, is that your understanding of the offer that the defendant will be waiving today? Negotiations will continue and eventually defendant will be pleading to a global resolution of CCW.
Yes, CCW with HIDA up at circuit court, correct.
Okay. Is that correct with Ida?
That is correct, Your Honor.
And Ms. Wicks, may I inquire of your client to the preliminary examination?
You may.
And the
Your Honor.
waiver. All right, thank you. Mr. Way, you understand you have the right to a preliminary examination today, correct? And just so we cover that, the prosecutor also has a right to a preliminary examination. That's a hearing, a probable cause hearing in which the prosecutor would have to prove by witnesses and proofs that at a probable cause standard that it's probable cause that the crime was committed and probable cause of the identity of the person who committed that crime. You understand that? If you waive your right to a preliminary examination today, you'll be waiving that right to a preliminary examination, and you're going to be going to circuit court, which is a different court than this court, and that'll be where this case is resolved. Do you understand that? And there's an offer right now in a global resolution that once negotiations continue, that you'll be pleading to CCW with a HIDA with HYTA status in circuit court. Do you understand that? All right. You also have the understanding you can be represented by counsel during this process. You can test these charges, and Ms. Wicks from the Public Defender's Office is here for that purpose. All right. Is it your intention, and do you want to waive your right to a preliminary examination today? All right. And the prosecutor is also waiving the right to a preliminary examination?
Yes, Your Honor.
All right. I find the waiver to be freely, understandingly, and voluntarily given. And so you'll be waiving your right to a preliminary examination in circuit court. You'll stay in contact with it's Mr. Nichols, isn't it? As part of this case?
It is. He is the attorney of record in the file.
All right. So you'll stay in contact with Mr. Nichols. He will get you your next date in circuit court. All right. Because they set it themselves. So you'll get it from him. All right. So stay in contact with him. Do you have any questions of me, Mr. Way? All right. Anything else for the record, Mr. Wisty?
No, Your Honor.
Ms. Wicks?
No, thank you, Your Honor.
All right. That's all for the record. This file 22-00822. Good luck to you, Mr. Ware.
All right, thanks.
Thank you.
Thank you, Your Honor. Have a good morning.
So is he on the, is that?
Yeah, that's him in the blue.
All right. So on the record in docket 21-01385, that's people, the state of Michigan versus Carter Reese Van Steele. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Thank you. Good morning, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Van Steele, who appears today via Zoom or Polycom, I guess, from Kalamazoo Psychiatric.
And sir, you are Carter Van Steele?
Yes,
Okay, and you can hear me all right, Mr. Van Steele?
yes, I'm able to hear well.
All right, thank you. This is the time set for a competency exam. Mr. Wisty, how are we proceeding?
Your Honor, my understanding is the parties will be stipulating the report. I believe that's going to lead to the court finding incompetent and sentence for further proceedings.
Mr. Palmer?
That's an accurate statement, Your Honor.
Yeah, I've had the opportunity to review the report. I find that, as indicated to the report, that there is a finding of competency. I'm willing to, I have an order in the file and I'll sign it to that effect. And then is this is going to be set for preliminary examination?
That's correct, Your Honor.
And it's set for prelim?
I think, oh, I'm sorry. I think we need a date, Judge.
Yeah.
Do we know if he's going to be still in Kalamazoo, Mr. Palmer, or is he being moved back to Ingham County?
That's the one issue, Judge, that I do not know the answer to. It's unclear to me, and it's unclear to my client, why it is that he is still at the Kalamazoo Psychiatric Facility as opposed to being transferred back to the Ingham County Jail. It's my hope that, or I guess it's nothing more than a guess, but I will say, I suspect that probably the reason is that they keep him until till the order has been signed to find him competent, at which point he would be transported back. That's my guess. So hopefully that'll kick in. That's my only hiccup, Judge, in terms of setting a date, is I obviously I need my client.
Right, and I do think it's based on finding the order first today, and then I sign it, and then it'll go from there. So we probably want it, do you want to set it out past the writ date to be safe?
I was going to set it for September 1st, which is 2 weeks from today.
That should work, yeah. So we'll set the prelim for September 1st.
I'm sorry, what time, Judge?
I'm sorry, 9 o'clock.
9 o'clock. And I've signed the order for the record. And that should be plenty of time if a writ is necessary. All right. Anything else for the record in docket 21-01385 from the people?
No, Your Honor.
Anything, Mr. Palmer?
No, Your Honor. Thank you.
All right, Mr. Wisty, we'll see you on September 1st, okay?
Mr. Van Steele.
I'm sorry, Mr. Van
You'll
Steele.
see me as well.
Yeah, I will. Mr. Van Steele, I'll see you on September 1st, okay?
Okay.
All right, thank you. That's all for the record in this file, 21-01385. All right, we're on the record in docket 22-01345. That's People of the State of Michigan versus Jennifer L. Pressman. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Erin Robinson, Assistant Public Defender, on behalf of Ms. Cressman.
And ma'am, you are Jennifer L. Pressman?
Yes.
Okay. Mr. Wisty, this is the time set for preliminary examination today. We've had some discussions already off the record. How are we proceeding today?
Your Honor, the case is to be transferred to the 55th Mental Health Court that's pursuant to an agreement. And in that court, the plea will be entered to a misdemeanor, attempted assaulting, resisting, obstructing. In this file, the remaining counts will be dismissed, and file number 21-2939, also currently before this court and being transferred, will be dismissed in its entirety.
So my understanding, just so it's clear, then for the ROA, for this ROA, guilty plea in 55th, it appears the resisting, obstructing in this file, and then all other charges to be dismissed.
Yeah, it would be an amended charge of the attempt.
Okay. Oh, the attempt RNO.
Right, yes.
Let me make sure I got that. Okay.
Count
Attempt,
one would be amended.
attempted RNO amended, and then all other counts to be dismissed.
Correct.
And Ms. Robinson, that's your understanding of the plea agreement as it's transferred to mental health
Yes,
court?
correct. So the plea and the sentence will all be done by 55th.
All right.
The mental health.
And Ms. Cressman, you understand the case is going to be transferred today to 55th District Court?
Yes.
All right, and Ms. Robinson, they've explained to you why it's being transferred to 55th and the nature of the plea agreement. All right. Do you have any questions of me, Ms. Cressman? Anything else for the record, Mr. Wisty?
No, Your Honor.
And anything, Ms. Robinson?
Just briefly on the 29-2939 SM file, I think there is a pretrial date of the 29th. I was just thinking maybe we could just leave that on for like a control date and we don't need to appear in person. Or she doesn't need to appear in person just to track it to see how it's going in 55th, if that's okay. or-
I don't think I can set the 55th schedule.
Well, so it
So it's
will-
in front
it-
of me?
Yeah, because this is currently in front of you, so I don't know if it will be fully transferred by that date. So I'm just asking, like, if she
Oh,
would
I
need to
see.
appear for that date.
I
because-
wouldn't think if she's in 55th, she has to appear for the pretrial in front of us.
Technically, it works on our docket. That case won't be dismissed until it goes up. And now it's presented to this. court.
So why don't we do this? Why don't we leave it on for pretrial? Mr. Wisty, you contact us and you let us know where the paperwork is. Because I don't want to create another date for her to appear if she doesn't have to,
Right,
you know, and if we've got a pending docket, if you indicate that the paperwork's set, then we'll relieve her of the responsibility of appearing in court.
and I can update the court as well. And if I receive word that like maybe they're still working on it, but it's still
Right.
being processed,
And
we could waive her appearance possibly.
correct, and
Okay.
you're usually here on pretrial days anyway. which is-
Correct, yes.
Okay,
I just wanted to make sure
All
she
right.
didn't have to come for, something that.
not, if the paperwork's all set, it's good. I know where the file is, so I'm not too concerned about it, all right?
Okay, thank you, Judge,
All right, thank you.
Don't worry
Any-
about it unless I get something new in the mail.
unless I tell you to.
Yeah,
Yep.
keep in contact with Ms. Robinson, she'll let you know, okay? That's all. Anything else for the record, Mr. Wisty?
No, Your Honor.
Ms. Robinson?
No, Your Honor, thank
All right,
you.
thank you. That's all for the record in 22-01345. That's all for the record. 22 -01920. That's people of the state of Michigan versus Darnell Plummer. This is the time set for prelim. Will the parties please introduce themselves for the record?
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Plummer, who's standing to my right, Your Honor.
Sir, you are Darnell Plummer?
Yes, Your Honor.
All right. This is time set for preliminary examination. Mr. Pfeiffer, how are we proceeding today?
Your Honor, today people will be filing a nollie in this file as the people are unable to proceed due to the necessary witnesses failing to appear.
Oh, wait. Oh,
So if I might approach.
you may. And Mr. Feigelson, I assume you have no objection?
No, not today, Your
All
Honor.
right.
No, it's Judge Clark, let's say. I don't want to lose my partner.
So I've signed the order for Nolly Cross. I'll give it to Ms. Golden. And-
May I get a copy as well as Mr. Plummer, please?
Yes,
Thank
I
you.
just signed the back. Just sign them both. Mr. Plummer, the cases today have been dismissed. All 5 counts or 4 counts have been dismissed against you. They're dismissed without prejudice, which means the people could bring it back if they choose to, but for today's purposes, all the counts are dismissed. Do you understand that?
Yes, sir. Your Honor.
All right, thank you. Is there anything else for the record in docket 22-01920?
Not from the people.
Anything, Mr. Feigelson?
Nothing from the defense, but I just wanted to advise Mr. Plummer of this, at least through today, maybe even into tomorrow, the no contact order still may be in the system. So just be careful with what contact till that clears.
That's very well said. I mean, it'll take some time for the no contact order to get out of the system. So to be safe, so you're not in violation, just on paper, it's 24 to 48 hours.
Yes, sir. Your Honor.
All right, thank you. Anything else?
No, Your Honor, thank you.
Thank you. That's all for the record, docket 22-01920. So we're on the record in docket 22-01982. People of the state of Michigan versus Nathan Crate or Crite. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of the defendant, Nathan, is it correct? Yes. Great.
And sir, you are Nathan Crate? Okay, thank you, sir. This is the time set for preliminary examination today. How are we proceeding? Mr. Wisty?
We will be running the prelim, Your Honor. Before we proceed with that, I would like to place on the record an offer that has been made and rejected.
Okay,
And the offer that was made was in this file, a plea to count one, that's assault with intent to do great bodily harm less than murder or by strangulation. This is a strangulation theory. There would be an agreement to a jail cap of 6 months. Count two would be dismissed. There would not be any, the people would not proceed with any witnesses or any charges involving witness intimidation, nor would the people proceed with a file that is pending against Mr. Craig.
To
All
be
right.
clear, Your Honor, that file has been signed by my office, it's awaiting swear to. So if you were to take that offer, we would work to stop that from being sworn to in its tracks.
okay, so
Judge, the other thing we did discuss, and I know the people had discussed the potential of adjourning this exam out to allow the people some opportunity to have the other cases involving the same alleged victim run together, Your Honor. I'll leave that up to the court what it wishes to do. I don't believe my client is in agreement with that adjournment.
Your Honor, I will say for the people, this was adjourned already because the 11th hour calls were discovered that the defendant had made to the victim's number. He then made more calls, including as recently as 9 p.m. last night. And because of that, I think it would be appropriate to adjourn out so those can be properly analyzed by a detective. And I don't think it's the people's fault that the defendant continues to violate the court's orders and produce evidence of new crimes as recently as the night before the hearing. And I think an adjournment would be appropriate.
Mr. Feigelson?
Your Honor, I'll leave that to the court. I'll take no position, given that Mr. Craig is against it, Your Honor. So I would ask that we run the exam today.
All right, my understanding is that the defendant has not waived his right to waiver of 21 days.
Correct, Your Honor.
And we are ready to go today. So we'll start the preliminary examination today. Which would indicate, and it's already been adjourned for good cause one time. So we're gonna start the right to a preliminary examination within 21 days. And then I'll leave it to the prosecutor's discretion once witnesses are called, whether they need to proceed further on further charges. So at this time, the people may call their first witness.
Thank you, Your Honor. The people called Dan Riedel.
No problem.
All right, Officer Riddell, I'll swear you in right here. Please state your name and spell your last name for the record.
Officer Dan Riedel, R-I-E-D-E-L.
And officer, raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes, Your Honor, I do.
All right, thank you, sir. You may have a seat. And Mr. Wisty, when you're ready to proceed.
Thank you, Your Honor. Good morning, officer.
Good morning, sir.
Where are you employed?
City of Lansing Police Department,
How long have you been employed there?
24 years.
Were you working on July 26, 2022?
Yes, sir, I was.
And in that capacity, did you come in contact with the Nathan Crate?
I did.
Do you recognize him here today?
I do.
Could you point him out? State the article of clothing he's wearing.
He's seated in the defendant's chair wearing Ingham County jumpsuit, gray in color.
May the record reflect the witnesses identified the defendant.
Any objection?
None, but I will cross on it, Your Honor.
All right. So without objection, the witnesses identify the defendant.
And then where did you come in contact with Mr. Crate that day?
In a wooded area to the northwest of 2511 North King,
What city is that in?
city of Lansing.
Is that County of Hingham?
It is.
How did you end up going to that area that day?
Our dispatch, our call center received multiple calls of a woman in distress or witnesses believing to hear or see a woman in distress.
And when you arrived at the scene, did you come in contact with a woman in distress?
I did.
And who was that woman?
Amber Heckerman,
Did she make any statements to you?
she did.
What were those statements?
She stated that Mr. Crate, her boyfriend, had strangled her by using a stick or a club. She stated that she thought he was going to kill her. She was shaking and trembling as I spoke to her. She was only wearing a bra and underwear.
Did she indicate when this had occurred?
It happened just before she had called. She was one of the callers. She was on the phone with 911 when I made contact with her. On a
Did you-
railroad track.
Did you identify yourself as a police officer?
I did. I was wearing full uniform, the same uniform I have on today.
I may approach your honor.
You may.
And may the record reflect, I'm showing the witness what has been identified as People's Exhibit 1. It's a series of 3 photographs.
Record may so reflect.
Thank you, Your Honor. Officer, do you recognize those photographs?
I do.
What are they?
This is a correct representation of the way I saw the victim on that day. This is marks and dirt and images of her neck from the scene.
Are there any marks on her neck?
You can see where there's obvious marks of some type, ring around her neck covered in dirt.
Are those consistent? Are those marks consistent with the statement she made to you?
It is.
How so?
She stated that Mr. Crate held a wooden stick, basically like a baton or baseball bat type size object. She stated that she was laying face down and that he was on top of her. She stated that Mr. Crate put that object underneath her neck and then used his body weight to keep her held down while he pulled up on that wooden stick. In turn, she was unable to breathe, stating that she couldn't breathe. She did indicate that she did not lose consciousness, but she couldn't breathe while the incident took place. She relayed it took place for several minutes.
And did she tell you anything about a relationship with Mr. Craig?
She said they've been dating, I believe, for approximately 9 months. They have no children in common. She told me there's been a history of assaultive behavior, and as she told me, at least 10 separate incidents had taken place. She stated that she had called the police to make a report on one prior occasion.
Thank you. And at this time, I would like to submit into evidence Plaintiff's Exhibit 1 and publish it to the court.
Any objection?
No, Your Honor.
Without objection, plaintiff's exhibits, all marked as plaintiff's exhibit 1 to 3 photographs are admitted in evidence.
Thank you, Your Honor. I have no further questions.
Cross-examination.
Yes.
Your Honor,
Mr. Pfeiffer,
that's all right.
follow-up witnesses, you can go ahead.
Just to clarify,
Okay.
this location that you,
Objection. I was under the court rule, if he's gonna direct examine a witness, you only have one lawyer do the work. I don't think he can tag in the middle of the questioning.
I think you're questioning on different counts, are you not? Or on
no,
the
Your Honor, I'll
same?
sit back down.
Okay. All right, fair enough. I thought they were on the added counts. I think if they're not on the added counts, Mr. Feigelson, cross-examination.
Thank you, Your Honor. Good morning, Officer Riddell.
Good morning, sir.
You've been with law enforcement for 24 years, is that correct?
That's correct.
Thank you for your service. And you were called out to this location on July 26th of this year, is that correct? And before that, this day, have you been in contact with either Ms. Hagerman or Mr. Crate?
I have
How many times before?
once.
With whom were you in contact with?
Mostly Mr. Crate, but I did briefly see.
Was it in connection to anything involving them too, or something unrelated to them? Was it in connection to situations involving both Ms. Hagerman and Mr. Crate, or something independent of that?
It was involving them both.
And she told you what happened, is that correct?
On this occasion, the prior,
This occasion on July 26th.
yes, she did.
And you mentioned that there were some photographs. Did you take those photos?
I did not.
Do you know who did take those?
Yes, I-
Who took those photos?
Officer Brown,
And you were present during those photos?
I was.
And you mentioned that there was some sort of club or stick used, is that correct?
That's correct.
Did you ever find any club or stick? Did she ever tell you what happened to that club or stick? What'd she say?
She said that after he had followed her into the field with the stick, and after she had called 911, she believes he threw it in the weeds or into the woods.
Did you and law enforcement try to find it?
We did not.
Why not?
It's a stick in the middle of the woods. And the area was massive.
And did you take any statement from Mr. Crate on that day?
I did not take a statement from him.
You know if he spoke with any of the other officers present?
I believe he spoke with Officer Brandon.
And Officer Brenneman was there, and you said Officer Brown as well, is that correct?
Correct.
And since July 26th, have you done anything else in regards to this case?
Well, I take it back. This morning, I went to that location where we arrested Mr. Crate in an attempt to locate the victim, to make sure that she was aware that the court case was taking place. Their camp has been since removed.
But other than that, you've done nothing else? Okay. And you didn't witness any of this, is that correct?
I did not.
I have no additional questions. Thank you.
Thank you. Redirect.
Just for clarification, that campground is in Ingham County.
It is.
No further questions.
May I make one inquiry? Where were these photographs taken?
Those were taken at the scene.
Okay, so at the 2511 North King City Lansing scene?
Correct. We use that address because where they were actually at is a massive field
Okay.
behind that building. There's railroad tracks and the river run through there. And that's the only place we can get to it from 25.
All right, thank you.
You're welcome, sir.
I don't have any further questions.
Nothing further from the people.
Without objection, can this witness be excused?
Yes, Your Honor.
Mr. Feigelson?
Yes, Your Honor.
All right. This witness may be excused.
Thank you, sir. Thank you, John.
Any further proofs from the people?
No, Your Honor.
Any proofs from the defense today?
All right. I hate to do this, but there is a witness here that obviously the people didn't call, but Miss Hagerman is here today, Your Honor. I'd like to put her on the stand. If I may.
All right.
Miss Hagerman,
Miss, so it's Miss Heckerman? All right. Ms. Heckerman, I'm gonna have you stand right here and spell and state your first name and last name and spell it for the record.
Amber Heckerman, AMBER HECKERMAN.
All right, and kind of raise your right hand. Do you solemnly swear, Ms. Heckerman, to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, you may have a seat here, and all I'd ask you to do is project to the back of the room so we can record, okay?
Okay.
All right, you may proceed, Mr. Feigelson.
Thank you. Good morning, Miss Hackerman.
Good morning.
I want to turn your attention back to July 26th of this year.
Yes, sir.
Where were you?
In the woods.
Okay, and where would that be?
That would be exactly where the officer said it was. It was behind the Peckham building,
Okay,
kind of off to, by the river.
you and Mr. Crate were living there together, is that correct?
Yes, we were.
And it was in a tent, is that correct?
Yes.
And you were, what happened next as you were there that day? What was going on?
Well, I had been informed that by another source that he was cheating on me. And I was furious. And so I went off.
Okay, let's slow down and unpack this a little bit.
Okay,
So you got word that he was cheating on you, is that correct?
yes,
And you confronted him on, is that right?
yes.
What did you say to him during this confrontation?
Basically, I didn't want to hear anything he had to say.
And
And so I was furious. I'm bipolar and I have, I go in and out.
are you on any medicine for your bipolar?
No, I have an appointment coming up on the 23rd,
How long have you been diagnosed bipolar?
since I was in my teenage years.
And you have been on medicine in the past?
Yes, I have.
And tell me about that.
Nothing really worked. It just made me groggy. Either I had a allergic reaction to it or it just didn't work. So
And you were
I
suffering,
also tried to not think that I had a problem. And I do.
were you suffering from any episodes from your bipolar that day?
Yes, I was.
So you were accusing him of cheating on you, is that correct?
Yes,
And what'd you do next?
I punched him in the mouth
Why'd you punch him in the mouth?
because I didn't believe him.
Action, Your Honor, we could approach.
You may. Right. Mr. Flagos, you talked about this.
Yeah, yeah.
Is there any lawyer
Andrew
present?
Yang is in the building. I have Rob on the check.
Yeah. I think Mr. Roston's here too.
All right, I think either of those lawyers could take the time to explain.
I think that's.
On the record in docket 22019882, we were in the process of listening to the testimony of Amber Heckerman when it was decided after some off-the-record discussions with counsel that maybe it was time for Ms. Heckerman to speak to a lawyer concerning some of her testimony and the consequences, and maybe some Fifth Amendment rights should be discussed. It's my understanding that that's occurred.
It has, Your Honor. She consulted with Andrew Yang.
And so, Mr. Yang, you're in the courtroom today.
Yes, Your Honor. Joseph Yang, on behalf of the witness Amber, it's okay, I've been called worse. It's okay. Amber Heckerman. I have had an opportunity to speak to my client, and I advise both the prosecutor and defense counsel that she does not plan to continue testimony, and they have agreed to that, and we'll move on to the next witness or the next portion.
All right. So at this time, she's invoking a Fifth Amendment right after speaking with you.
That's correct, Your Honor.
Okay. Thank you, Mr. Yang. And so we will discontinue. Well, Mr. Pfeiffer, is that your understanding?
It is, Your Honor. The people do not plan to have any questions based on what's been testified to.
All right, Mr. Feigelson.
I had nothing else, and I probably had one other question for her anyway, and I'm satisfied with what I got. So
All right. So with that understanding, the witnesses invoked their Fifth Amendment right after speaking to counsel. Mr. Feigelson's case is up right now because he called the witness.
Correct.
So, Mr. Feigelson, do you have any
I
additional?
do have no
witnesses
other
today?
witnesses today.
All right. Mr. Wisty, do you have any further proofs?
No further proofs, Your Honor.
Okay, a motion for bind over.
People would move to bind this matter over on both count 1 and count 2. Count 1 is the insult with great bodily harm, less than murder by strangulation. By strangulation is the theory here. We heard testimony that's admissible pursuant to statute from the officer investigating this, that the accused took a stick of some sort, wrapped it around the victim's neck from behind and pulled on it to the point where she lost her ability to breathe. I believe that shows strangulation, and that coupled with the photographs where I believe you can see a clear wound on the victim's neck is enough evidence to bind this matter over on the assault by strangulation. Subsequently, that's also a domestic violence, as we heard testimony in a dating relationship. So I believe that's enough to bind over on count 2 as well.
Thank you. Response to motion for bind over, Mr.
I
Feigel.
guess I would ask that this matter not be bound over today. I want to talk about a couple of things. We heard testimony from Officer Liddell, Your Honor, but he wasn't present during the event. So he really doesn't know what happened. He took a statement from Ms. Hagerman at the day of the event, but Ms. Hagerman testified here in court today and said she accused my client of cheating on her. She didn't like any answer she gave him, and she socked him in the face. So that's her testimony today, Your Honor, and then she invokes her Fifth Amendment. So that's all I need to say here, Your Honor. Based on her testimony, which is of the alleged victim in this case, she's saying she threw the first punch. So to me, there's been no crime, Your Honor. Coupled with the fact, let's look at Officer Riddell's testimony. He said that there was a stick. He knew where potentially there could have been a stick. He made no effort to try to find this stick. If you look at the pictures, there's hardly any evidence from the pictures to indicate there's been any strangulation. But more importantly, Ms. Hagerman took the stand under oath and testified to punching my client, Your Honor. I'd ask that this case be not bound over today. Thank you.
Thank you, counsel. Any response?
I would just say the self-defense is an affirmative defense. I don't think what's been shown here is enough to overcome probable cause. Nothing further. Your Honor.
The standard for preliminary examination is probable cause being the second lowest standard in criminal law. It's the second lowest standard. Only lower standard is reasonable suspicion. The highest standard, of course, would be the standard of conviction for beyond a reasonable doubt, which would be a circuit court standard. I find that there's no dispute that this happened on July 26, 2022, that the identification was made in court of the defendant, Nathan Crate, that the venue is the city of Lansing, Ingham County, state of Michigan, that the location is really the park in the vicinity of 2511 North Martin Luther King, city of Lansing, Ingham County, as testified by Officer Riedel. He was the one witness who testified for the prosecutor, and then there was brief testimony from Ms. Heckerman prior to the adjournment. So really what's left is the offense, elements of the offense. And I do find that an assault was committed upon Amber Heckerman by strangulation or suffocation based on Officer Dan Rydell's hearsay testimony, which is allowable pursuant to the statute, that the testimony was that there was an initial altercation and that she was hit several times, and then a club or stick was used in the middle of the woods to put under her throat and to pull upward as she was facing downward in order for her to lose. The indication was she did not lose consciousness, but she could not breathe. And then the stick was thrown. There's sufficient testimony at a probable cause level to believe that the crime of assault with intent to create bodily harmless and murder did make an assault on Amber Heckman by strangulation and suffocation has been met to a probable cause standard by hearsay testimony. The count 2 of domestic assault is part that they had a resident or former resident of the household or an individual, they had a dating relationship and assault occurred, is also follows as a misdemeanor. However, with the third offense notice that on 2 previous occasions, this defendant is found guilty of domestic assault, it would indicate that this is then bound over on a 5-year and or $5,000. Losing my voice here. The testimony is found through the testimony of Officer Dan Rydell, hearsay testimony, and then the exhibits, which are not egregious, so to speak. I believe Attorney Feigelson is correct. However, there's definitely red marks in the throat area, which would indicate and corroborate some of what Officer Rydell saw. The only testimony that prior to the witness taking the fifth at pursuant to counsel's instructions concerning any consequences of that testimony was an indication that there was a punch thrown initially and that she was angry. But I think Officer Rydell's testimony concerning what was said at the scene is probable cause testimony enough to bind over the case as the charges are bound over as charged in this proceeding. Anything else for the record, Mr. Wisty?
No, Your Honor.
Anything, Mr. Feigelson?
Yes, Your Honor, I'd like to address bond if I may.
You may.
I believe the bond is presently set at 10,000 cash. I'm sure you may be off on that, but I believe that's what it's presently set at. Your Honor, I asked for a reduction today. A couple of things to point out. Mr. Crate does have a job here in town. Your Honor. He works at Zeus Coney Island on South Pennsylvania. He's been there a couple of years as a dishwasher / cook. I'm concerned since he's been sitting in jail since July 26, he may lose that employment. That employer is waiting on him. So I'd love to get him back out into the community so he can work here. He is willing to put on a GPS tether to monitor his whereabouts, Your Honor. And I'm under the assumption that, but I can't confirm that Miss Hagerman is not going to be in the area. So the concern of him having any contact isn't there. But if the court's inclined to put a tether or not a tether, but a monitor where we can't go anywhere near a known address to Ms. Hagerman, I'm supportive of that, Your Honor. Given all that, I'd ask for a PR bond today. Thank you.
Thank you, Mr. Feigelson. Mr. Pfeiffer on bond.
I think GPS tether is a great idea, but in no way, shape, or form should this man have a PR bond. First of all, he doesn't plan on staying in the area. He plans on going to Detroit to be with the victim. I know that because I've listened to the calls between him and the victim. Which brings him to the other point. He called the victim, spoke with her about her testimony today at 9:36 p.m. last night. That's one of 61 calls that he has made to the victim. In those calls, he has told her to lie, to say that she lied, and that it'll be okay if she gets in trouble. He's also was begging her to get his bond posted before the 18th, when his court date was, that being today. So that way he could get out of here. If he's given a PR bond, we'll never see him again. That's the long and short of it. We'll see him again when he commits a new felony. He is being investigated for witness interference and witness bribery. He has another charge with the same victim, with the same charges, that is currently working its way into the court system, as I signed off on that about a week and a half, 2 weeks ago. And when I get back to my office today, I will be contacting my detective again to make sure it gets to the courts to be sworn to. Your Honor, because of all this, I believe the bond is very appropriate and should remain where it is. Thank you.
Thank you. I heard nothing today that would indicate that a reduction of bond is in order based on the testimony from the officer and then the representations made on a pending case of domestic. And then what the most concerning is the continued contact with the victim up until last night on phone calls, and every phone call is recorded. So it's not as if those phone calls are somehow a secret in any way. So I find more, and there's a no contact order still out there. And so it's obvious to me that the no contact order has been somewhat of a failure. And the only way to address the safety of the victim in the case, whether they recognize it or not, or to recognize the pending cases or the safety of the community, is to have bond continued. I'm not going to raise it. I have an inkling to raise it, but I'm not going to raise it. $10,000 cash surety is the bond. It'll stay at $10,000 cash surety. I understand counsel's argument. After seeing the testimony, and it is warranted to ask for reduction of bond. I just don't see it given the circumstances of what I heard today, and then the extraneous pending domestic assault file, and then the phone calls that happened up until late last night. I think anybody would see this record and indicate that we're in a very sensitive proceeding and a very dangerous proceeding that could entail. So 10,000 cash surety is the bond set. It'll remain the same. Your motion is denied. Anything else for the record in docket 22-01982? Mr. Wisty.
No, Your Honor.
Mr. Feigelson.
None, Your Honor.
All
Thank
right.
you.
All right. So this case is bound over to circuit court. Stay in contact with Mr. Feigelson and he will give you the next date for arraignment.